No matter what question I wanted to ask this medical expert, he did everything except answer yes, no, or I don't know. I was so tempted to turn to the judge and ask him for his help. Is that going to help me cross-examining this particular medical expert? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So this was a medical malpractice case, and I had an opportunity to cross-examine the defense's medical expert. He's up on the witness stand. His attorney has asked him tons of questions for hours already. And now I get up to ask him questions. And every single question that I ask him, the doctor gives me a long-winded answer, which I really didn't want. And I wanted to keep interrupting the doctor. In fact, I first started to interrupt the doctor, telling him, "No, doctor, that's not what I'm asking for." And now we got into a verbal sparring match. And I'm thinking, oh my God, this doctor's being so argumentative with me. And this was early on in my career. I was so tempted to turn to the judge and say, "Judge, can you help me here? Can you tell the doctor to just answer my question?" Why would that be such a terrible strategy? I'll tell you why. Because then it shows to the jury that I'm weak. It shows to the jury that I can't control this medical expert. You want to learn about an incredible strategy I learned after that trial? It's as simple as this. As I get up to question the doctor to cross-examine him, I will lay some ground rules. Doctor, I'm going to be asking you a series of questions. Those questions are only going to call for a yes, a no, or I don't know, or I can't answer the question. That's it. If you cannot answer the question, will you tell me that? Yes. If you can, if you agree with my question, will you tell us yes? And if you disagree, you'll tell me no. Fair enough? Good. And now I'll go ahead and proceed with the questions. Doctor, I want you to assume that the following facts are true. Would you agree that doing A, B, and C would be a violation from the basic standards of medical care? Now, if the doctor wants to give me a long-winded answer, I have every right to stop him and say, "Excuse me, doctor, you promised just a moment ago to answer the questions either yes, no, or I don't know, or can't answer the question. Which one of those answers is right for this question?" And now if he begins to argue with me and still tries to explain away everything that I'm asking him, now the doctor is the one who looks argumentative. The doctor is the one who now looks like he's got a hidden agenda. In order to accomplish this and get this done effectively, I have to only ask short leading questions, literally putting the words into the doctor's mouth, requiring him to only agree or disagree. And if I don't do that effectively, then this whole strategy doesn't work at all. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on during cross-examination, especially in a medical malpractice case here in New York. You know, I recognize and I acknowledge you're watching this video because you likely have questions or concerns about your own particular problem. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.